Weaponized Secularism, The Legal Assault on Hindus in the Name of Minority Rights, Part 2. Written by Aditi Joshi. India must choose between appeasement-driven distortion and a just civilizational renaissance. True secularism begins when Hindus are no longer second-class citizens in their own homeland. In the first part of this series, we conducted a detailed exploration of how India's post-independence legal and constitutional order systematically institutionalized discrimination against the Hindu majority. Rather than adopting a neutral framework of governance, the Indian state constructed a legal edifice where secularism was redefined not as equal treatment of all faiths, but as state-sanctioned favoritism toward religious minorities. A close examination of Articles 25, 28, 30, and 44 reveals how religious propagation rights have been used to enable aggressive conversions, how Hindu educational institutions face restrictions while minority-run ones enjoy greater autonomy, how Hindu temples have been brought under state control, and how personal law reform has been selectively enforced on the Hindu community alone. These legal asymmetries are not isolated anomalies. They reflect a consistent policy orientation embedded in the political and ideological framework of post-colonial India, one shaped by Nehruvian socialism, minority appeasement, and an enduring unease with India's Dharmic civilizational identity. This second part goes beyond laws and courtrooms to look at how Hindus are sidelined in everyday life. It shows how land control, sacred symbols, government narratives, and institutions have been used to suppress Hindu heritage while promoting minority interests. What started as legal bias has now grown into a deeper civilizational shift, where the majority culture is slowly erased, its symbols discredited, and its people made to feel powerless in their own country. Hindu marginalization is thus not simply a result of misguided secularism. It is the outcome of decades of cultural engineering and political inertia that have combined to hollow out the core of India's civilizational soul. This phase of the crisis demands not only legal rectification but a cultural, educational, and civilizational awakening. Waqf Board supremacy and property seizure. One of the most glaring examples of institutionalized religious privilege in modern India is the extraordinary authority granted to Waqf Boards through the Waqf Act of 1995, further strengthened by amendments in 2013. These boards, tasked with managing Muslim charitable endowments, wield quasi-judicial powers that override standard property laws. Most notably, they possess the unique power to unilaterally declare land as Waqf, even retroactively, without the consent or prior notification of affected individuals or institutions. This legal regime has created a parallel sovereign structure. The 2011 Satcher Committee report revealed that Waqf properties span over 6 lakh acres across India, making the Waqf Board the third largest landowner in the country, after the Indian Railways and the Defense Ministry. These properties encompass mosques, graveyards, commercial buildings, residential complexes, and agricultural land. Estimates peg the value of these holdings between 1.2 Indian rupees and 2 Indian rupees lakh crore, roughly 15-20 billion US dollars, a scale that reflects both material clout and systemic impunity. What makes this framework even more extraordinary is the absence of a comparable institution for Hindus. Temple lands, many of which have been donated over centuries by devotees, are routinely brought under the control of state governments through the HRC, Hindu Religious and Charitable Endowments, Acts. These lands are often mismanaged, encroached upon, or auctioned for non-religious purposes, with little legal recourse available to the Hindu community. No centralized authority or legal protection exists to defend the sanctity or autonomy of temple assets on the scale of the Waqf Board. The asymmetry deepens when we examine the procedural powers granted to Waqf Boards. Under Section 40 of the Waqf Act, any land can be notified as Waqf based on the board's own inquiry, and any objection to such notification must be heard not in a regular civil court, but in a specialized Waqf tribunal. These tribunals are often opaque and function with a presumption in favor of the Waqf claim. The burden of proof lies overwhelmingly on the defendant, often reversing the presumption of innocence, a clear violation of the spirit of Article 14 of the Indian Constitution, which guarantees equality before the law and equal protection under the law. Instances abound where properties, private and public, have been declared as Waqf without prior notice, triggering protracted legal battles. Critics have rightly noted that the Waqf Board operates almost as a parallel land ministry with unchecked powers, minimal accountability, and disproportionate protection under the law. This institutional imbalance deeply affects property rights, civil liberties, and social cohesion. When religious minorityism becomes part of the state's operating logic, it warps both legal fairness and civilizational unity. The unequal treatment of Hindu and Muslim religious lands isn't just a policy flaw, it's a systemic injustice that calls for urgent correction. The marginalization of Hindu identity is not confined to the legal and institutional frameworks, it extends deeply into the symbolic and sacred terrain of India's civilizational heritage. This involves the systematic denial, distortion, or devaluation of sacred spaces, religious narratives, and cultural memory associated with Hindu civilization. Denial of sacred heritage. Ram Setu Affidavit, 2007. In 2007, the United Progressive Alliance (UPA) government, through the Archaeological Survey of India (ESI), submitted an affidavit in the Supreme Court claiming that there was no historical evidence to prove the existence of Lord Ram or the Ram Setu, Adam's Bridge, a formation held sacred by Hindus for centuries. The affidavit was filed in the context of the Sethusamudram shipping canal project, which proposed dredging the limestone shoals connecting India and Sri Lanka. The ESI's assertion that Lord Ram was a mythological character and the bridge a natural formation sparked nationwide outrage. Hindu organizations, cultural bodies, and civil society activists condemned the affidavit as a direct affront to civilizational beliefs and national identity. The government was eventually forced to withdraw the affidavit, but the incident exposed a deeper malaise: the tendency of the Indian state to treat Hindu sacred history as mere folklore while affording deference to minority religious narratives. Scientific and religious counter-evidence exists. A 2003 satellite image study by NASA revealed the bridge-like structure between Rameswaram and Manor. While NASA distanced itself from any theological interpretation, Hindu traditionalists and scholars cited this as archaeological corroboration of the Ramayana's claims. Noted geologist Dr. Badrinarayanan, former director of the Geological Survey of India, also affirmed that the formation was man-made and dated back thousands of years. The episode demonstrates how secular rationalism in India is selectively applied, often to delegitimize Hindu civilizational claims while avoiding similar skepticism toward Abrahamic traditions. The dismissal of Ram Setu was not just about a canal. It was about severing the civilizational memory embedded in geography. Places of Worship Act, 1991. The Places of Worship, Special Provisions Act, 1991, mandates that the religious character of all places of worship as they existed on August 15, 1947 shall be maintained. This statute was passed during the height of the Ram Janmabhoomi movement and was aimed at preserving communal harmony. However, its implications are profoundly unjust. The act preempts legal recourse for Hindus seeking to reclaim temples that were destroyed or converted during Islamic rule. Some of these temples are well documented in contemporary accounts, archaeological evidence, and colonial surveys. The only exception made was for the Ayodhya Ram Janmabhoomi site, whose legal proceedings were already underway. Temples such as the Jayanvapi Mandir in Kashi and the Krishna Janmabhoomi in Mathura, both demolished and replaced with Islamic structures, are effectively barred from redress under this law. As per the ESI's 1991 report and earlier colonial-era surveys like James Prinsep's documentation and Alexander Cunningham's ASI records, both sites have been subject to extensive desecration and appropriation. Critics argue that the act violates both Article 14, Equality before the law, and Article 25, Freedom of Religion, of the Constitution. It denies Hindus the legal remedy to reclaim sacred sites based on verifiable historical wrongs while granting permanent status to colonial and medieval-era injustices. Legal scholars such as former Chief Justice of India R.C. Lahoti and jurists like Harish Salve have noted that freezing the religious character of contested sites effectively sanitizes the historical record and entrenches injustice as policy. In a country undergoing decolonization, this law acts as a colonial vestige that weaponizes secularism to suppress Hindu civilizational memory. The Ram Setu controversy and the Places of Worship Act together reveal how state machinery and law have been used not for justice, but to delegitimize Hindu sacred symbols and block historical redress. The aim is not just maintaining social order, it is exerting ideological control over India's civilizational narrative, even if it means suppressing historical truth and severing spiritual continuity. Minority First policies. Enacted in the aftermath of the Babri Masjid demolition, the National Commission for Minorities Act, 1992, institutionalized a centralized mechanism for protecting and promoting the rights of religious minorities, primarily Muslims, Christians, Sikhs, Buddhists, Parsis, and Jains, added in 2014. While intended to safeguard disadvantaged communities, its operational framework has produced a dual welfare state in practice, where benefits are determined by religious identity. Through the Ministry of Minority Affairs, created in 2006, minority communities have access to exclusive schemes such as minority scholarships for school and college students, merit and need-based scholarship for professional and technical courses, leadership training for minority women Nai Roshni, interest subsidy for education abroad Padho Pardesh, grants for minority educational institutions, Maulana Azad Education Foundation grants. However, there are no equivalent schemes for impoverished Hindu communities, particularly Dalits and OBCs, who do not qualify as scheduled castes the moment they convert out of Hinduism. Even in states where Hindus are a demographic minority, such as Nagaland, Mizoram, and parts of Kerala, they receive no institutional support equivalent to the National Commission for Minorities outreach. This religiously segregated welfare architecture violates the spirit of Article 15(1) of the Constitution, which prohibits discrimination based on religion, race, caste, sex, or place of birth. It has led to the institutionalization of minorityism, where identity-based entitlements create parallel citizenship regimes. Deceptive secularization of the Constitution. The word secular was not part of the original Constitution made by the Constituent Assembly. It was added later during the emergency in 1976 through the 42nd Amendment, a time when democracy was weakened, civil rights were taken away, and Parliament was silenced. This change was never discussed by the original drafters of the Constitution, and it had serious ideological effects. In India, secularism was meant to show equal respect to all religions, Sarva Dharma Sambhava. But over time, it was used to selectively silence Hindu voices in the name of keeping peace between communities. Examples of this ideological bias include restrictions on Hindu festivals like Dahi Handi in Maharashtra or Jallikattu in Tamil Nadu, while minority religious processions often get police support. Censorship of Hindu themes in films and books, while content related to minority religions is protected by blasphemy laws and careful editing. Removal or dilution of Hindu content in government textbooks, while Islamic and Christian institutions are allowed to retain religious character under Article 30. Legal scholars such as Justice J.S. Varma have observed that Indian secularism suffers from interpretive incoherence, often acting against the majority religion instead of being neutral to all religions. Inserting the word secular into the Constitution's preamble has, in practice, weakened Dharmic traditions and encouraged vote bank politics based on identity. Together, the National Commission for Minorities and the distorted meaning of secularism have created a system where the state shows favoritism in the name of fairness. This has led to not true secularism, but an imbalance, where the majority religion is tightly controlled while minority groups are officially supported. Toward a civilizational reckoning. The cumulative effect of these anti-Hindu policies has led to a steady erosion of Hindu autonomy in independent India. What began as legal asymmetry has matured into full-fledged cultural marginalization. The very civilizational framework that once nurtured pluralism and coexistence now finds itself cornered by institutions and narratives that render the majority community invisible or suspect in public life. Temples are administered by state bureaucracies. Festivals are subject to judicial scrutiny and bureaucratic regulation. Sacred heritage is labeled mythology, and Hindu symbols, texts, and traditions are caricatured in popular culture and sidelined in educational curricula. Simultaneously, Hindus are cast as aggressors in public discourse, even in contexts where they are historically the aggrieved party, such as in temple desecration, partition violence, or cultural appropriation. This loss of civilizational identity cannot continue for long. When the majority of a society is cut off from its own cultural and spiritual heritage, the nation loses its unity and strength. The state's moral authority weakens when it cannot acknowledge the historical pain and contributions of its core population. India is at a crucial crossroads. What we need now is a Hindu civil rights movement, not to demand special treatment but equal treatment, not to dominate others but to uphold dignity, not driven by revenge but guided by Dharma. Restoring balance. To correct these distortions, India must undertake a comprehensive reform agenda that restores institutional balance and civilizational authenticity. Legal reform, repeal or amend discriminatory statutes such as the Places of Worship Act, 1991, which freezes historical injustice, and reform the Waqf Act, 1995, to ensure transparency, accountability, and parity in land governance. Institutional parity. Extend constitutional protections, financial grants, and educational autonomy to Hindu institutions on the same terms as those offered to minority groups. Temple reclamation. End state control of Hindu temples through HRC acts and restore their administration to traditional and community-based structures. This is essential to revive temples' spiritual and social role in public life. Cultural sovereignty. Recognize, protect, and promote India's sacred geography and Dharmic heritage, whether it is the Ram Setu, Kashi Vishwanath, or Mathura Janmabhoomi. Civilizational memory must not be censored for the sake of vote bank sensitivities. This includes correcting textbook distortions, supporting Dharmic research institutions, and safeguarding traditional knowledge systems. This is not merely about justice for Hindus. It is about restoring balance, integrity, and authenticity to the Indian Republic. A truly secular state must also be truly equal. That equality cannot exist as long as the civilizational majority continues to be treated as a colonial subject in its own homeland. The time has come not to apologize for Dharma, but to anchor democracy in it. Cultural memory and the battle for India's soul. Beyond laws and institutions lies a deeper realm, the terrain of cultural memory, where civilizations are either preserved or erased. For thousands of years, India's memory lived not just in scriptures and temples, but in oral traditions, festivals, symbols, and everyday rituals. Today, that memory is under attack. From school textbooks that omit the crimes of invaders, to films that mock Dharmic traditions, to public narratives that portray Hindu identity as a problem. Insert textbooks still downplay the destruction of temples, gloss over Islamic iconoclasm, and portray Bhakta saints not as spiritual seekers, but as social rebels against so-called Brahmanism. Bollywood often distorts Hindu imagery, casting demons as misunderstood victims and saints as shady figures. Meanwhile, academic spaces, influenced by Marxist thought, dismiss India's civilizational story as nothing more than a majoritarian myth. This erasure of memory is no accident. It is a deliberate effort to disconnect Hindus from their cultural roots, making them easier targets for ideological takeover, whether by Western universalism or Abrahamic exclusivism. A people cut off from their memory become easier to manipulate. Reviving this memory isn't about nostalgia. It's about survival. It means reclaiming indigenous knowledge systems, protecting sacred spaces, teaching history honestly, and taking pride in Dharmic heritage. Civilizational self-respect can't be outsourced. It must be lived, taught, and defended. The battle for India's soul won't be won only in courts or parliaments. It will be won in homes, temples, classrooms, and cultural spaces, wherever Hindus remember who they are and why that memory must never fade.